Well, thank you guys all for coming, for technical difficulties and bearing with us. This is the legal panel, Video Game Lawyers Live and Pontificating. I'm my name is Joe Newman. I'm a video game lawyer. I've been practicing for about 10 years in the video game industry. Worked for EA, Ubisoft, went into private practice and counseled, Tencent, Amazon, Meta, and a bunch of other indies, and done a bunch of stuff in the game space. And I've been coming to MAG for forever, and I love doing the video game panels. And I am thrilled that I have these wonderful panelists with me in virtual space. I'll let them introduce themselves very quickly, and then we can get started. Sam, you want to start?
Okay, sure. My name is Sam Castry. I'm currently a solo practitioner, so Sam Castry Law. I've also been a video game lawyer for about a decade now, and also been coming to MAG for about forever. I have a lot of clients who are small, kind of mid-sized indie game developers, and so that's what I've been doing, and hopefully will continue to do for quite a while.
That's true. Vita, you want to introduce yourself?
Yeah. Hi, everybody. My name is Vita Cruz. I'm a practicing lawyer for 3.5 years now over at Gearbox Entertainment. If you guys know, we make Borderlands and Wonderlands. I wish I had something for that. But I'm super happy to be here. It's my first MAGWest experience at all, so thank you for having me.
Awesome. And then, Sam, I mentioned, so unfortunately, we were going to have another panelist here in person, Riley, who formerly of Capcom, now at Jam City. She actually got into a fender bender on the way over, and so she's...
Oh, no!
Yeah, it's pretty gnarly. I'll show you what the... She won't be upset, but she got rear-ended real bad.
Dang. That's not good.
So she's like
Even
on the
worse.
side of the road. Yeah.
Even worse technical difficulties than I'm having.
That's
Great.
true. It puts it in perspective. So anyway, so we are video game lawyers. We have a couple of topics that we want to talk about and things that we see in our day-to-day practice as games lawyers. But since most of the time we're speaking to other lawyers, I really like coming to MAGWest because I love hearing what you guys have to say and what your questions are and what it's like to be a video game lawyer and what it's like to work in this space. And actually, maybe let's just kind of kick it off with that real quick. Like, what was your journey to becoming a video game lawyer? Actually, wait, even before we get there, are there any lawyers in the audience? No. Anybody who's like thinking about becoming a lawyer, like law students? Sometimes we get those. Okay, just oh yeah, cool, right on. Any musicians? Nice. Any game develop? Sorry, you should see this. Any game developers? Nice. Indie game developers. People looking for legal advice? Good, because we can't give it on this panel. So, awesome. So cool. So, Vita, do you want to just talk about your journey into where you are and how you got to Gearbox?
Yeah, for sure. So basically, last year of law school, and I didn't know what I wanted to do. Pretty sure people can relate. And I took this video game law short course, and it was amazing. It changed my mind about everything. And I knew as soon as I took that course that I had to get into the video game industry no matter what. So I didn't stop. I had to breathe. But I didn't stop doing anything until I got there. So I went to GDC. I'm a CA. So for 4 years, I've been doing the CA thing. And it helped me network with people in the game industry. And it was an amazing networking experience.
What does CA stand for? Sorry,
conference associate. So if you've ever been to GDC, the people with the really bright neon shirts that help you when you have issues, those are us. And we're just a very tight-knit community. And like I said, I met my boss through there, saw him again at another event. And after I graduated law school, I passed the bar. And then I reached out to him again, and I was like, hey, do you have any job openings? And then turns out he did. And I was really lucky to be interviewed and flown out, and I got the job. So that's how I started practicing at Gearbox. And it's been an amazing 3.5 years at this point, and I'm just super happy that I get to work on amazing games.
Right on. Sam, you want to tell? I know you've been probably practicing longer than any of us, but what your journey into games?
Sure. So I went to law school, didn't really know what I wanted to do, and then as I was finishing up, didn't have any job prospects lined up. This was 2013, so the recession had just happened. Everyone decided, I guess, I'll just go back to law school and write it out. And going to school in Chicago, there are like 5 different law schools in the Chicago area, so lots of people, not a lot of jobs. I'm here figuring, well, what the heck am I going to do now? And I actually had a friend, now I think a mutual friend of ours, who she currently works in-house at Epic, but she was in school with me, and she was going to be a video game lawyer, and she knew it, and she was going to do it, and she had this giant plan all worked out. And now I'm sitting here, I just passed the bar. What am I going to do now? Well, maybe, is that a thing? Could I be a video game lawyer too? I don't know. So I just looked up a bunch of game developer meetups in the Chicago area and started showing up. And like, well, hi, I'm a lawyer. You might need to know some of this law stuff. So I'm going to hang out and be a resource. You can ask me questions that aren't legal advice. And if you ever need something, a lawyer. And eventually, people needed a lawyer. And so I've kind of been building things up that way for the most part. And, when I can afford a flight, coming out to things like MAGWest and hanging out and doing panels like this and meeting people and whatnot. So it all kind of happened by necessity and happenstance at the same time. But I've really enjoyed the ride so far, except for the horrible poverty. But otherwise, the practice is good.
Sounds good. So I think let's just jump right into substantive law stuff. So, I think we have a bunch of topics that we want to talk about. I think one of the most sort of top of mind issues for all of game development right now is AI. I think game studios, there's obviously lots of controversy. There's lots of socioeconomic and, PR issues about people's use of AI and, displacing artists. But there are also a lot of legal issues as well. And I'm curious, Vita, just in your experience of being in-house, and your developers probably tell you they want to use this technology to make their lives easier. So what are some of the legal issues that kind of come up?
Yeah, let me start by saying that the law and the ethics of AI are different, and that is something that we've had to make clear at the studio, where like our thoughts about how AI should be used is not necessarily what the law may think, or if the law is even caught up. So I'll just say that to start, because there have been lots of discussions in the studio. There are plenty of artists, like Gearbox, of course, that completely agree with AI and think that it should be used in its maximum capacity. And there are those that think that AI is the worst. It's ripping off everyone's work. And yeah, there's just polar opposites in opinion sometimes. But at the studio, basically, we have all sorts of people who want to use it. The artists want to use it, like Midjourney, for example. Then the coders want to use something like, Copilot. And then you have, well, there's not too much in the voice world. Oh, are we still here?
Yeah. Yeah.
Okay, sorry, I heard a weird noise.
Oh, here, I'll point you towards me so you can at least see. Yeah. All right, keep going.
Oh, okay. So yeah, there some of the considerations that we take into account and that we think about is the extent of the use of the AI. Like, are you using the AI tool in order to create a really important part of the game, or are you using it to create something that's a little more mundane? So an example that I've given before is like, are you using it to create a lot of different types of grass for your environment and your level, or are you using it to create your main character? Sometimes that distinction makes a big difference, because the copyright office might not like it if you used AI to create your main character, and then you wouldn't get protection over it, and then that becomes an issue as a developer, because you want to make sure that your work is protected. So we don't want to risk having the really important assets in our projects being lost to AI in any kind of way in terms of protection. So for the most part, if it's something, like I said, simple, that is not highly unique, then we are more okay with it. But when it comes to things that are supposed to be unique and stand out, then we start to get into the weeds a little bit, and then they would be better served by asking legal if it's okay.
Yeah. When we talk about the value of a video game, like the way that video game companies value their intellectual property, or that value themselves, I mean, the IP is extremely like Borderlands is a very valuable IP. They're going to make a movie out of it. Vita and I know each other actually because I helped, with Embracer's acquisition. We were helping, doing that. But like your IP is what is super valuable, both, for your company, and you need to make sure that you own it, right? So the one key thing about AI generated material is that it can't be copyrighted. If it is not created by a human, the Copyright Office has said it's actually not protectable. And a lot of artists, a lot of creatives are using it in their creative process, not realizing that just means it's open game for anybody else. So that is, if all of the legal deterrents for using AI haphazardly, that's probably the biggest one. You don't even get to own your game if it was, too heavily AI generated. And along the same lines, like you need to know what parts of your game are created by AI and what parts are not, because if there's ever a legal challenge later, you need to have the records, or else the Copyright Office may just invalidate the entire thing.
Yeah, I just wanted to add real quick that documentation has become huge. Game devs in our company are really good about documentation through Jira or whatever other tools we use. But when it comes to making sure that we know what portions of the asset were created using AI versus what portions they added onto it or did by themselves, it's important to keep records of that. So just keep it in mind if you're using any of those tools.
Yeah, in particular, I know that the temptation to use AI for indie devs is very high. So like, even if you're using Copilot, like one of the tricky things about Copilot, and I've messed around with it, is Copilot will generate the code for you, but you don't actually necessarily see which lines of code were AI generated. If you just look at the code, it all just looks like code. So putting in comment text when you've used Copilot, that's just sort of like a best practice. So, it's okay to use it, but then to have something in the code that actually says this code was generated by Copilot. It's kind of boggling to me that Copilot doesn't have that feature by default. I think that is something that needs to change, because you just need to have an audit trail. You need to know what parts of your code you own. And Sam, I know you do a lot of work in the patent space. Are you seeing AI come up in that as well, or how is it affecting your practice? I guess I'll say.
I don't do much in the patent space.
Oh, okay.
I've worked for a patent lawyer in the past, but that's okay. For me on sort of the lower level, I mean, it's certainly a topic that comes up a lot, and use of this. And I know some of my game dev friends have even started some kind of AI discussion group coming up. So I know it's out there. I know it's a thing people are talking about. I also know a lot of people, as we've said, are dead set against it. Both on potentially legal and potentially misguided legal grounds, as well as moral grounds and economic grounds and all that. So I haven't had to deal with it a whole lot myself, and maybe just nobody's telling me they're using it, and that'll be a fun thing to deal with in a couple of years. But I haven't seen a whole lot yet. I know a lot of the indie developers and contractors that a lot of my clients or my clients work with, are not looking to get replaced by computers anytime soon. So it's a lot more of people kind of doing their own work. But it's, as a tool, it's potentially useful. I know it can potentially save a lot of time and effort and headache. So we're just going to kind of have to see where this goes and what the courts decide to do with it once it's presented there, because I think that's the biggest issue for me is, so is it okay to do this? The answer is we don't know yet. I'll tell you as soon as the appellate courts get their hands on it. See in 4 years.
Yeah, I mean, I think that's absolutely true. And one of the other things is we've talked a lot about this kind of in the academic legal sense, but the work that the AI spits out can't be owned, but what if that work contains other copyrighted material? Because obviously if you tell an AI to create a Borderlands character, it's going to look at Borderlands art, and it might create something that has Borderlands logos and stuff on it. So we caution our clients, don't have your employees feed company IP into something like Midjourney, because you may not own that thing that pops out. If that thing that pops out looks a lot like the thing that you did want to protect, that creates a very difficult legal question for a future infringer, right? They say, oh, I didn't copy your character, I copied this Midjourney character that was free to copy. So again, these are issues that we haven't fully seen the aftermath. When somebody, actually we did see one, Samsung got in trouble because they were feeding trade secrets into the AI, and now they lost the trade secret protection, right? And they didn't really, it was an employee who didn't know what he was doing, right? But like you have to be very careful, because that stuff, once you put it in, it's out there.
And it becomes harder at scale, I'd say, because with a huge company like Samsung, it's really hard to keep track of what every single one of your employees are doing. And when the big craze of AI came out, everybody was so excited to try it. It was whether it was ChatGPT or whether it was Midjourney or DALL-E or whichever one of them. Lots of employees and people in general are just super excited to use it. So one of the ways that we've kind of thought about mitigating that risk is, instead of putting it into this public data set, what if you create a more internal data set and feed all of your company's IP into that internal data set, and then anything that it outputs is owned by you, and whatever you put into it was owned by you. So it's a much safer realm when you only use the company IP into your own AI data set. Yeah. That's one way that you can mitigate the risk, and it's been toyed with.
Yeah. It doesn't necessarily help you own if it's not copyrightable, but it does protect against the things getting out. Agreed. All right. Well,
important never to be a test case in the courts.
Yeah, there hasn't been a test. Exactly. Yeah, we don't know yet.
Don't be that case.
Yeah, exactly. All right. Well, let's pivot. I'm sure we're going to get questions on AI, but we'll circle back. We'll have time for questions at the end. So one of the things that I spend a lot of time worrying about is as a consumer protection focused attorney. So I do consumer protection, I also do IP, but a lot of privacy. One of the probably biggest areas of enforcement in the games world is when it comes to kids and kids' privacy. So I don't know if you guys saw, but there was a huge, almost over $500 million settlement that the FTC reached with Epic Games this year, or December of last year, about kids and kids' privacy issues playing Fortnite. And for, I think, who here plays Fortnite? Just so actually not that many people, but you know why? It's because all the kids are playing it. And that's for a lot of people in the industry, it was a little bit shocking to see Fortnite, which is a game where you shoot people in the head with sniper rifles, and it's rocket launchers, and it's a battle royale. That's a kid's game? I think a lot of people probably mistakenly thought that being rated T for teen, or even, potentially M for mature, means that, this isn't subject to kids' privacy laws, it's not directed to kids. And the FTC very clearly, with this case, said, nuh-uh, kids are playing these games. They cited the fact that Fortnite was selling kids' Halloween costumes and Nerf guns, and they're very clear that kids were part of the demographic.
I have some of those at home.
Do you really?
Nerf gun.
Nice.
Yeah, one of my kids has a Fortnite Nerf gun.
Oh.
So
definitely. So.
And
yeah, it made total sense. Is that a kid's game? Yes.
Yeah, of course.
My kids know it. Of course
absolutely.
It is.
So on some level, it's obvious, but it also kind of means that basically every video game, other than Tax Simulator 2023, almost every game is likely to be seen as appealing to children. And that means that every game developer now has an obligation to start thinking about proactively what are the risks that my game might present to a kid, and how am I going to mitigate those risks. So anybody have stories to tell of your game companies trying to address that, or if not, I can tell stories. But
oh, sure. Yeah, for me, there's not a whole lot. It's to the point, typically it's more all ages, not like kid focused. So now we have to worry about it, but also for more like single player experiences, there's not as, I know, of course there is some data being, and especially if you have a website, send an email comment or whatever, you have to worry about that. But it's not as though we're making something that all the kids are talking about on the playground and buying toys and whatever. So it hasn't quite. Again, I'm not quite on the level where we super have to worry about that for a lot of clients, but it still gets to the point. People come and like, so your privacy policy, can you whip one up for me? Well, what are you doing?
What are you doing?
What are you collecting? Oh, nothing. Okay, well, do you do this? Well, yeah, I guess. Okay, can you act as this? Well, yeah, I guess if I wanted to. Okay, so let's sit down and actually figure this out.
Yeah, I think a lot, particularly
in
the indie space in particular, I think there's a kind of underestimation of how much data you do want to collect. Even if your game is single player, particularly if it's ad supported, well, that requires a lot of data, and you're going to want to have ad SDKs, and they collect data and they collect persistent identifiers. But even if you're, even if you're like an offline only game, I think a lot of indies forget how important like user acquisition and like marketing campaigns are for their game, and those marketing campaigns collect data. And if you work with a marketing agency or if you work with somebody who's trying to promote your game, they're going to run campaigns, and those campaigns are going to get data collected. And I think it is definitely something that all indie games, any game maker needs to be thinking about the data that they're collecting. Is that anything you want to add on that, Vita? Yeah.
Well, thankfully, we haven't had to worry too much about the kids because a lot of our games are M-rated, so we're not really in that sphere. But when we started to work on, which Tiny Tina's Wonderlands was the first game that I was at Gearbox for from start to finish, which is super exciting for me. It was like my first game credit. Anyway, point is that was a team game. So once that game came out, or before that, we had to start thinking about, okay, well, now there's a different age bucket that we have to start looking at. What kind of data are we collecting, and how do we need to change our privacy policy to make sure that it's in line with the myriad of privacy regulations that are out there? Because it's not just the US, it's also the EU, and there's like a lot of other countries in the world. I could point to a map, but like there's a lot of them, and you have to take into account all of them. So yeah,
absolutely. Yeah, I mean, I'm curious, has anyone here tried to do like a GDPR request for their data? Oh, somebody's nodding.
Sorry, not a request for my data, but I've had to like code it for my website.
Oh, you've had to code it. Oh, interesting. So like to respond to people who are requesting their to access it, delete it, or both?
I used to work for an education company, so there's a lot of like angry parents that are doing an audit of us to make sure that we're not, gathering anything from anyone who's 13 and under.
Oh, I see. So they'll be like, I've actually heard that some regulators will do like sting operations where they will go to a website and say, "Hey, I'm 8 years old," and see like how long it takes for them to basically get banned. Yeah, that's interesting. So. Did you get a lot of complaints from parents? I mean, I know in the education space.
Well, sorry, GDPR is the one that's the European Union one, yeah. So it's mostly just like different regulators, like you said, that are doing audits to making sure that like we're not turning on all cookies, things like that.
Nice.
Parents' thing was more COPPA than GDPR.
Yes, yeah, COPPA is definitely the big one. There's another California-specific one too that's coming into effect. So anyway, we could definitely talk a lot about it, but we'll move on. So I think let's talk a little bit. Do you want to talk, Sam, maybe a little bit about the merger space and the Microsoft case? I know you've talked about that in other contexts.
Yeah, I've given a couple interviews on that. This is still ongoing case. Microsoft Activision merger, the FTC isn't happy about. I know. Quick rundown, $68 billion something deal between Microsoft trying to buy Activision Blizzard. Federal Trade Commission said, "I don't like the look of that. Let's look more closely into this." From the get-go, I've never been impressed with the FTC's complaint and some of the allegations they're making. One of the big ones is they're trying to like hyper-focus define the relevant market as just Xbox and PS5, which I think is very misguided, given all the other ways people can play games at this point. But a couple weeks ago, they had a hearing. The actual trial isn't until next month, but they had a hearing in front of a California federal judge asking for a court order, don't let the merger happen until we have our trial. And I didn't watch all of the proceedings, but from what I have seen and read in summaries, and then the judge's opinion, FTC did a very bad job of presenting its case, as I expected they would. And the judge came out and said, no, we're not going to pause this deal. You were not likely to succeed. That's part of getting a court order like that is likelihood of success on the merits of the case. Are you probably going to win? Judge said nope. Also, given everything, it's really not fair to pause this deal, so no also. And sometime today, the temporary order stopping the merger is going to expire. Yesterday or thereabouts, the FTC put in another request to pause it until they can finish appealing the judge's decision. The judge said no. And so now I believe what happened just now is the FTC is now asking the appellate court for an order stopping the merger until the trial happens. And Microsoft filed a response that essentially said, no, you shouldn't do that. They haven't given any good reason why the judge was wrong. And so that's pending. They have the deadline to complete the deal before potentially a $3 billion penalty kicks in and possible renegotiation that costs a bunch more money is the 18th. And so that's kind of everyone's deadline. That's why there was a lot of stuff happening all at once the last couple of weeks to get in ahead of this deadline. And the FTC has kind of been dragging their heels on some of these filings, and I continue to not be impressed, and I continue to say, yeah, it's probably going to happen. I mean, and personally, I have no strong feelings about Microsoft. I haven't had an Xbox since the original Xbox, so I have no dog in this fight, other than I've predicted what's going to happen, so now I have to care professionally. But one way or the other, I don't really care. I just, looking at this as a longtime gamer and a longtime game lawyer, I think it's going to happen. So fingers crossed for my friends at Microsoft, and we'll see how good it goes for everybody.
I think it's worth taking a little bit of a step back. So who is familiar with the FTC? It's the Federal Trade Commission. Yeah. Okay. So I mean, this is the perspective of lawyers who've been doing this for a bit. So the FTC is, it is a consumer protection agency. The reason that they are trying to stop the merger is because they think that it's bad for consumers. They think that it's going to create a monopoly that's going to result in higher prices or worse quality, or the people won't get as good service because Activision and Microsoft will band together and they will exclude Sony essentially, or Nintendo or whatever. And it's part of, I think, a broader trend of the FTC that they're getting really aggressive. And I mentioned like the $500 million penalty against Epic. They also had a multi-million-dollar penalty against Xbox for COPPA issues. They were actually relatively benign as far as COPPA issues go. We don't have to get into it, but like they're being very aggressive, and they recently did an order to show cause saying that basically Meta can no longer monetize the data of anyone under, I think, either 18 or 16. Like no making money at all from this data. And Meta was like, you've just killed our entire business, basically. It's not just, I mean, we all have our thoughts and opinions about Meta, but the point is like they're being very aggressive, and as Sam was saying, is like they maybe could be overreaching, right? They could be, they're going after some really, big fish. They've announced that they're planning to like take on Amazon's core business, for antitrust violations. And it's really interesting because we've seen, it's a situation. Again, this is just my personal opinion, not representing a client, but like they are, fighting these battles, and they are fighting. They're doing so in a way that they could end up losing and could end up really hurting their own credibility, and that makes me a little scared as a not a huge fan of late stage capitalism.
Yeah, I have no love for mega corporations buying anything, let alone slightly less mega corporations. But just looking at the complaints, like, what are you doing? No, stop. There could have been better arguments. I think this is how many other studios has Microsoft bought up in the last few years. Like, that's a bit of a concern. But really, it was the whole thrust of the complaint was we don't want them making a worse Call of Duty for PlayStation, which makes me wonder what some of the FTC people, what side they're on in the console wars. It's like big concern.
The reality is it's really hard to make an antitrust case. I mean, there was the case that Epic was trying to bring against Apple and Google, and it's just really tough. Because as you said, Sam, like there's a lot of different ways you can play games today. And you don't have to own one console. You don't have to, own one phone. I mean, most people only own one phone, but still, like, you don't, there
you have options on phone.
Yes, you have options, and even with respect to Fortnite, you certainly have many options with which to play Fortnite. You can play it on your computer, you can play it on your phone, you can play it on a console, and it's free to play. So it's like it's harder to make a monopoly-based argument when there's just so many different ways to experience games, and the critical analysis when you're talking about market penetration and dominance in an antitrust is what is the relevant market. And if the relevant market is Xbox games, well then yes, Microsoft has an monopoly on Xbox games. But like, if the relevant market is all games, well then they're barely even they have some influence, but they're not the whole market. Well, cool. So we have other topics we can talk about, but I kind of feel like I want to switch over to Q&A a little early. We can always head back. Just do people have questions and things that they are curious about? Yeah. Go ahead.
Anything?
Yeah.
Yeah, I have one about that first topic you were saying about concerning copyright of AI-generated material.
Mm-hmm.
Because I've heard a lot of conflicting sources compared to what you guys were saying about how if I generate something with Midjourney or what have you, like let's say I'm a game dev and I design my main character, to the T of what a Midjourney prompt output.
Mm-hmm.
You're telling me that a copyright office would say, oh, you don't actually own the copyright to that if I went to go obtain it?
So the question was using a Midjourney output and then modifying it to create your character, right?
Okay.
Is that right?
Yeah.
Yeah.
Or just taking the character produced by Midjourney outright and being like, okay, that's the character in my game,
Yeah. So we actually have a pretty good case on that. I don't know. So there was a person who created a comic book called Zarya of the Dawn, and it was using. I'm gonna have to mute that. I don't know how to mute that. Using, I think it was Midjourney that they used to create the images of of the comic book. They then made touch-ups to them, and then there was a lot of iteration that happened of where they were, iterating on the prompts and doing new ones, and then they obviously had to select, arrange them and put them into the comic book, format to tell the story that they were wanting to tell. So the Copyright Office said, great, well, you don't own the images of your that were used because they were created by AI, and the adjustments that you made were not sufficiently creative. You were just doing touch-ups. They don't suddenly transform it into a different work. Now, you do still own the story that you told and the selection and the arrangement of the panels. So, like, if someone else created an identical comic book but with different art, you'd still have a claim against that because you were creative in telling the story. but you don't own the artwork because it wasn't created by a human. And so to your example, and obviously, I'm not giving legal advice or anything, but like if you're creating, if Midjourney created the heart and soul of the character, then that character isn't yours. Like it's basically free for anyone to use. And if you modify it, at best you might get some protection for those modifications, but someone else could just copy the source without your modifications and make their own modifications, and you wouldn't necessarily have a cause of action against them. Did I miss anything? Yeah, go for it.
I think that's right. I think just a general thing, a lot of copyrightable works have a lot of different components, especially, comics, you have the drawing, the story, the arrangement. Video games especially have all sorts of stuff, the code, music, sound effects, dialogue, stories, all that stuff. And some things can be protectable and some things aren't protectable. You can take something in the public domain and make a brand new thing out of it. Well, you can't stop, someone from using Pride and Prejudice, but you can protect the zombie stuff from Pride and Prejudice and Zombies. You can take a Shakespeare work and incorporate that into something else, and that's part of it. And you can write your own music, and if it's a video game, you have the sprite work or 3D models or whatever and everything, and that's fine. But if someone comes along and steals all the Shakespeare dialogue from you, well, didn't actually steal it from you because it was never yours. So a lot of what we have to look at is what exactly are we trying to protect here, and what was taken and what wasn't. And even if everything is copyrightable, you can't copyright an idea. It's one of the big things. It's the concrete expression of that idea. So, and there's never a clear line necessarily between what's the idea and what's the expression. So there can be a lot of kind of gray area fights around that. But part of copyright infringement claim is, okay, well, what did you actually copy, and how protectable is that? And that can really vary from one page to the next, so to speak, or the analogous for other media. But that's a big deal. So the answer always is we have to figure out what was taken and in what way, and how was it taken and how was it used, and that can vary wildly depending on even sometimes very minute factors.
Yeah, I think so. I'll just say one other thing. We'll take some more questions. But I think one of the tricky, nuanced things about this is that you don't actually need to own every piece of your game. And if you make a game using Unity assets or Unreal assets, you don't own those assets. You just got a license to them. But that's okay. You can still own your game. And I think this is a nuance that is very tricky, because if you use a Unity asset for your main character, well, you may you have to know what part of your game is valuable and is the thing that you're going to want to protect, right? So if it's valuable, if it's important, if it's your main character, if it's your setting, if it's your your lore, maybe create it yourself, right? If it's just like the textures of the grass, well, you don't really care if somebody copies that, right? So you can either buy an asset and license it, or have AI generate it. And for that reason, I actually think I'm a little bit more pro AI than other people, and because it can automate the stuff that you don't care about anyway. There's so much work that goes into creating a game that is not the creative stuff. That is the stuff that is just we got to fill up this room with content, and we have to have art on the walls, and it actually, for the story we're trying to tell, it doesn't matter what that art looks like, so let's just get something. And I think the good news about AI is that it allows you to spend more time on the parts of your game that you do really want to protect. The question for the lawyers is, how do we know which one is which? And how do we make it very clear internally when we are making that decision to sort of cut the corner and to say, hey, we're going to use AI for this or get a license for it. Actually, I see now a couple of different questions. So do you want to just line up at the, and we'll take them as they come? I got my Discord people. They're also asking silly questions. So.
Mine's a quick
Yeah.
follow-up to the previous thing. So,
Yeah.
so if you get an AI generating thing to design a character, and then you make all the art for your comic yourself, using that design, do you technically own then the copyright to all the art, but not the design of the character itself?
Yeah, that's a great question. So now you're talking about making a derivative work. Actually, do one of you guys want to take this? I can.
No, you're on the roll, Joe.
All right. So a derivative work. So think about Winnie the Pooh. So the character of Winnie the Pooh is, it's in the public domain. A.A. Milne is dead and the copyright is expired. But Winnie the Pooh wearing a red shirt is Disney's creation. It's their derivative work that's based off of the public domain Winnie the Pooh character. So if you, as a subsequent person, copy Winnie the Pooh with a red shirt, then you've infringed on Disney's intellectual property. But someone else can still copy the character of Winnie the Pooh because he's in the public domain. And that's why you have that Winnie the Pooh slasher movie, which is hysterical and really cool because you can't do it. That character is in the public domain. So along the same lines, you got to be careful if you're using AI. Somebody could then take that character, which you don't own, and put him in a slasher movie or put him in a porn parody, which is a thing that happens a lot, and you wouldn't have necessarily rights to take it down. So there's a trade-off.
Awesome. Thank you.
Thank you.
Hi, I was hoping to change gears a little bit.
Sure.
What are some common pitfalls for new indies that are just getting started, like setting up their LLC?
Absolutely. Yeah, Sam, that's a good one for you.
Oh, yeah. Oh, boy. We don't have time. So some things you're going to want to do. One, set up the company. If you're working with other people, figure out in what capacity you're working with people. Are they going to be business partners in it for the long haul, such that you'd be fine with them still sticking around, getting a cut of your profits 5 years, 10 years, whatever from now? Or are they just contractors? They're going to come in, compose your music, do a couple art assets, go home. In which case you'd want some kind of work for hire contract and spell out the terms. But the important thing to note, one, is that any copyright transfer has to be in writing. There's no, I'll just do this out, I'll do it, don't worry about it. It needs to be in writing, or you don't own anything. You might have some kind of license, a non-exclusive license, so anyone else could possibly also get these rights, but that's something. And whatever your core team is going to be around for a while, talk to them about what your plans are, what everyone's plans are, who's, division of labor and who's going to get paid what and who's allowed to make certain decisions and sign things and what percentage of you has to agree on these other decisions, and get that all in writing. Because what you really don't want, a year and a half into development, here's a big fat publisher check, but no one's really talked about this. And now suddenly I've done way more work than you have, so I deserve twice as much, and then everything falls apart. And that's never a good position for anyone to be in. So that's a big thing. Your timetable, be realistic about it, and then add like 20%. Okay. If you have some sort of deadlines, things will take longer, problems will come up, Unity will want to update and ruin half your build. These things happen.
It's Godot in our case.
See, nods in the audience, you know what I'm talking about. So insofar as you have any sort of deadlines, be realistic about them and pad things out a little bit. When it comes to game names, studio names, to a lesser extent, most people for indie studios don't care who you are. They know the game more than they know you. That's a trademark. You need to look into that. And before you even talk to a lawyer about getting things searched or registered or anything, take a couple quick steps you can do. Go on to like 2 or 3 search engines. put your game name in, see what comes up. Trademark infringement, we're looking for similar marks for similar goods and services. So if your game name comes up and it's, video games, maybe board games or something like that, stop. Do not pass go, pick a new name, start over. If it's nothing or nothing similar, at least, if it's your game name but for a grocery store, no problem.
Okay.
Probably not going to be a big deal, all in all. It's is the ordinary consumer going to sit and think, did the bodega down the street suddenly start getting into game development? No one thinks that. Don't worry about it. Unless maybe it's a supermarket-themed video game, which would be weird, so don't do that maybe. So, just take a look around. You search on Steam or Epic or whatever. Does something like your game name come up? Also, you can go on to the U.S. Trademark Office, uspto.gov. There's a trademark search function. Again, stick your name in, see what happens. Is it game software? Stop, pick something else. If not, that's the part where you're going to want to look into getting a lawyer to do some more in-depth searches and really dig in deep to all the little nuances of the records. Because again, what you really don't want is you're going, maybe you just start your Kickstarter, maybe it's even successful, and then a few months later you get a cease and desist letter from somebody saying, hey, wait, that's my game name. What are you doing? Stop.
Yeah.
And depending on what kind of right do they have, maybe you're in deep trouble, maybe it's going to be a big mess because no one has clear rights to anything, and then we want to avoid those problems early on. So just getting kind of that clear picture. When it comes to actually registering the trademark, you kind of have to balance, because there are fees. They're not huge, but I know a lot of indie devs don't have money to begin with, so anything is going to be an expense. You have to balance how long it's going to take you to have something ready to go. Even like a good vertical slice demo can be enough to support trademark rights, but you have to actually have a product available for people to play. It's not just, I had a Kickstarter, I have a company name, I have whatever. Can I go on Epic and click download now? If so, great. That's a trademark used in commerce. If not, not great.
Yeah. I will say. Sorry, go ahead.
Yeah. And just balancing your development cycle, because there's a time limit on how long you can have your application before you have to prove use, versus the fees of having to buy extensions of time to make all that time, versus how much money you have to deal with it, and so a lot of. Versus your risk tolerance. How do I need to protect this right now? Well, I'd be okay to wait 6 months. Yeah. Who knows? Yeah. And so that all kind of gets factored into the business decisions of when should we talk to the lawyer about doing this. Yeah. And so.
I also
go ahead, Joe.
Yeah, I'll just add one of the. So I forgot to mention where I work now, which is a boutique called Ty's Law Group, and we do a lot of trademark searches. Again, I do recommend talking to a lawyer, and Sam, and we can help you out. But I think another just sort of pro tip is also be very careful about like one letter off things. Okay. So like the standard is likelihood of confusion. So if you have like your game title has like 2 O's, think about if somebody types it on with only 1 O, or like replaces an I with an A, or like things like that, because those people can still come after you if there's like if you're both in the game space and there's only like a letter or a couple of character differences. The standard is likelihood of confusion, so that's the sort of thing. Yeah, sorry, we got a couple more minutes left, but thank you for the question.
That's a big part of the
that's a big part of what we do review. Is trademark searches.
Yeah. Go dig it in.
Yep. Go for it.
Oh, hi. I just wanted to circle back to data privacy, and you were talking a bit about like some of the different frameworks in the US versus the EU, and my understanding is like there's some overlap, but when it comes to the differences, to what extent does that kind of complicate like international data transfers, and are there issues along those lines kind of specific to gaming that maybe most people don't think about?
Sure. Yeah, so I'll answer it really quick because we talk a lot about it. So there is actually, as of this past week, the U.S. and the EU reached, and the EU made an adequacy decision saying that this new framework that the U.S. had come up with was safe when it comes to transferring data from EU to the U.S. The context here is people in the EU are scared, justifiably so, about what happens to their data when it comes to the U.S., in particular with respect to national security. This isn't really about private businesses. They're afraid because the U.S. government has so much power to subpoena and get information, and Edward Snowden and all that kind of stuff. They're afraid, if my data leaves the EU and goes to the U.S., then the feds are going to get it. It is weird that private companies are kind of pulled into this proxy war, but we have been for years. And the expectation, there's this guy, Max Schrems, in the EU. He's challenged the last two frameworks and gotten them both struck down. I think he's already announced that he's going to challenge this third framework. So like his goal in life is to make it difficult for U.S. companies. And that's, fine, cool. But it affects game companies because gaming is international, right? And, we're constantly trying to anticipate these legal regimes and these legal needs and to, exist in a world where pretty much nobody is fully, buttoned up compliant, and yet we all need to be. So it's a very general answer, but I hope that kind of helps.
Oh yeah, thank you.
Cool, thanks. We got time for a couple more, and then maybe some silly questions too.
All right, sorry for another AI question.
No, it's cool. I know AI is a hot topic.
I think this was lightly touched on before, but I was just wondering the copyright eligibility of, so say if you trained your own AI on your own copyrighted images of a character, and then you try to create modified characters with that data.
So the question was, if you train your own AI based off of your own copyrighted material, and then you want to use the output of that AI for modifications, is that right?
Either character creation or modifications. So say if you threw all of your art, like say Disney just threw everything in there to create a pretty good AI at that point, you could generally create new characters off that.
So Vita, is that something that your teams are kind of looked at? I feel like that's
we're looking at it now, and we feel much safer when that's the case, because we know that we know basically what's going into the data set and what it's being trained on. And if we feel comfortable that our artists obviously created it, from their own brains, then we feel way more comfortable with the output being something that is okay to put in the game. We're flirting with the idea, but again, when it comes to us, it's already kind of too late. So we'll see what happens. But people have definitely played with the idea.
Yeah, us being the lawyers.
Oh yeah, sorry.
Yeah.
Legal team. Yeah.
No, but I think, the question again becomes, did a human make the thing that you're trying to protect? Right? Because it might be safe from somebody else claiming that you infringed, but you may also, if it comes to light that the big innovation of your design was not made by a human, there's a risk there.
Yeah. Okay.
So I tell people it's cool to use AI for inspiration. Feed it a bunch of prompts, get some ideas, and then just make the thing from scratch.
All right, cool. Thanks.
Hi. A topic that I'd be interested to hear about is IP law surrounding video game collaborations. So a video game using the IP of, say, a movie or a comic or another video game. Big example being Fortnite. They do that a lot. So I was wondering if you could shed light on how that works, or maybe just talk on your own experience on it, or whatever.
Sure. So
all contracts, all the time.
Yeah, a lot of what I've done in my practice is these sort of licensing deals. So it's an agreement. Again, there is a business deal that gets worked out first, usually, where the marketing people of two companies say, hey, this would be cool if Chun-Li was in Fortnite. And actually, if Riley was here, it's too bad she's not, because that's a ton of what she did at Capcom, is these licensing deals. And it doesn't have to be in video games. It can be, I want Ryu at Baskin Robbins, whatever. Like, there are sorts of, like, the IP that the company owns is licensable, and it's freely licensable. And, it's a question, the lawyer's job in that situation is really just to facilitate the deal and make sure that it's fair. So sometimes it's relatively straightforward. We will pay you $50,000 and we get a license to use your character, and you get certain approval rights over how that character is going to appear. That's relatively simple. A merchandise deal, way more complicated, right? Because then there's usually a question of what's the cut that the publisher is going to get? Do you get to approve the manufacturer? Do you get to see the prototypes first? Who takes the responsibility if the merchandise catches fire and hurts somebody, right? Like, these are things I've had to deal with before, and it's kind of turnkey. Like, there are market, one of the reasons to go with an experienced lawyer is because there are sort of market standards and expectations, so you can know when you're deviating from the market norm. But ultimately, yeah, that's licensing. I mean, V, did you do a lot of licensing stuff at Gearbox?
Yes.
Yeah, I figured.
When I first started, we got Psycho and Claptrap in Fortnite. We got the Tiny Tina's the
right.
glider in Fortnite too. Yeah, so I worked on those, and I've worked on a couple of other ones, and it's always so fun to see like the collaborations between video games, like when worlds collide, and it's really exciting on our end to be like, oh my god, our character's gonna be in that game. That's amazing. So it's always a very exciting part of my practice when I get to see where our art and assets are gonna go in someone else's assets.
Awesome.
Yeah.
Okay, cool. Thank you.
Yeah, thank you. We have a couple of, these aren't actually that silly, but somebody
I'm disappointed.
from the Discord said, are there video game patent trolls?
Yes.
Yeah. The answer is yes. I don't know if we want to elaborate, but.
I could, don't.
Oh yeah, that's right. And you've dealt with some of them.
Yeah. There are patent trolls for everything. They go after everybody.
Yep.
There's usually sometimes the best defense when you get attacked by a patent troll is to attack the validity of the patent themselves, which there are unfortunately a lot of junky patents that are overbroad or abstract or not claimed correctly. So it can be a little bit of a dangerous game to threaten a big company with a patent lawsuit if you have a weak patent, because then they could invalidate it and there goes your meal ticket. But it is definitely, it's an unfortunately a annoying game to play because they troll because they ask for only enough money that you can just pay them and they'll go away. So it's always a question of, do I take the time and the money to fight this, or do I just pay and say goodbye? I deal with that a lot in the consumer protection context too. Like, people, they complain and they want like $500, and you're like, okay, fine. And it's easier, and it's a big business for them, unfortunately. Well, cool. Well, we are at time. Does anyone else have any burning questions? Otherwise, sure. Let's do one more.
Yeah, do I have to come up, or can I just?
Yeah, just so they can hear.
Okay, yeah. So earlier you mentioned that the FTC has gotten a little more active with how it's like bringing all these cases up. Is this more of like a proactive thing where they've started to just decide to do this more, or is it, I guess, like more of a general trend in the industry where you see a lot of these like, I don't know, a lot of these like mergers or just possibly anti-competitive things happening?
So I think there has been. I'll talk about the consumer piece, and then Sam, maybe you can talk a little bit about the antitrust piece. But I think they've always been active, and they've always been active in the game space, particularly around protecting kids. It's a very easy case to bring if you're a regulator and there are kids who are getting harassed, or their data is being harvested for targeted ads. Like, that's a very easy case to bring. The Fortnite case is an interesting one, both because they said, we're going to consider this as a game for kids. But then also because they said, even if it isn't a game for kids, we are still exercising our broad authority to go after unfair and deceptive practices with respect to the teenagers. And they were basically, it's kind of a land grab. They're saying, no, we can just say that this is wrong because it's wrong. And they have a very broad mandate to go after quote unquote unfair and deceptive business practices. But with a standard that's that squishy, it becomes a little bit, more interesting and more important that they use it in a way that's predictable. And I think that there's sometimes, I think that everybody kind of knew the Fortnite case was coming, but I was a little surprised by the Xbox investigation because there really wasn't a smoking gun, There was the biggest issue they found was that data wasn't being deleted properly. It wasn't being used for anything, but they was stuck in a silo and it didn't. That's a problem, but that's not like a multi-million-dollar problem. I was kind of surprised that they were so aggressive there. Sam, you want to chime in on the antitrust bit?
Yeah, I think in general, a lot of these tech companies are really big, and when you get really big companies, who then want to, especially buy up other companies, that is potentially a problem. And so, in terms of the Microsoft Activision merger, it makes total sense that they would at least want to investigate and see what's going on. That made perfect sense to me, and I think there could have been better complaints that could have been drafted on this, but based on the evidence, based on even just what Microsoft's been doing, the big thrust of this case has been, they're going to put Call of Duty not on PlayStation or put a really buggy, worse version on PlayStation. But Microsoft, despite all the studios they're snatching up, still makes a lot of things really accessible. They bought Minecraft, and now you can play Minecraft on everything. There's been no problem with that.
Yeah, they still make a lot of money from,
Oh, yeah.
Yeah.
For sure. GoldenEye is going back on Nintendo system. That. Okay, cool. Great. So I'm not really as concerned about stuff like that. Are there concerns? Sure, potentially. And so you investigate, you get all these documents, you look at things, but then there was nothing there. And at the hearing a couple weeks ago, there was nothing there, and the judge's opinion was yeah, you haven't even pointed to one piece of evidence, any sort of smoking gun, even a little bit at all. So the fact they're still pushing this makes me wonder what's going on, because the case was never great, and now all the evidence is out, or at least as much as we have so far. There was nothing there, and they lost pretty devastatingly at the injunction hearing. And the fact they're still pushing this, I don't get it.
Yeah.
Is it just we want to be taken really seriously and we won't let you get away with anything? Okay, I get that on the one hand, but you still have to pick your battles, because sometimes mega corporations do things above board, and you need to let that go. I'm a little concerned about. And there's another case the FTC lost recently too. What was it? I think it was involving Meta, but anyway. Yeah. So right there. Is there credibility taking a hit to this when we really want someone to be honest and above board and take the good cases and protect all of our data and market competition? I don't know what they're thinking. I don't have any contacts or experience inside the FTC, so I couldn't tell you. Yeah. But it's a little disheartening to see some of these stretches they're making that I think will only hurt them in the long run. Yeah. When people see this what, really? That's what you're doing with your time? Come on. So yeah, I don't know. Time will tell.
Yeah, well, it's a pendulum. Well, anyway, on that slightly ominous note, I want to thank again my wonderful panelists for dialing in. Next year we'll get you in person. Vita and Sam, thank you.
Where's
and thank
the
you
picture,
all.
Joe?
Yes. Awesome. Again, I'm running because I'm going to be performing in an hour. But if you guys have questions, come talk to us. Anyway,
What's your
thank-
show?
Oh, I'm playing with Ian Cowell on the main stage in like 4:20, so like in an hour and so.
Nice.
Yeah, I know we made it the funny number. Cool. All right, thanks guys.
Thank you. Bye bye.
Bye.
Thank you guys.
Thanks again, Jeff. Take care.